Here's a scenario. You're driving a car in good mechanical order, there's no issues with it whatsoever, and you're not committing any traffic infractions. Yet a police officer begins to follow you, he runs the license plate, and figures out that the registered owner of the vehicle has a revoked driver's license. Now, in this scenario, you're yet to know whether you're the registered owner or not. Of course, if you're the registered owner, you have a revoked driver's license. But it could also mean that you're the individual who's borrowing somebody else's vehicle. So here's the question. Can a police officer pull over this vehicle? In other words, does he have reasonable suspicion to believe that the person inside is committing a traffic violation? Is there reasonable suspicion to pull over this vehicle, or would he be violating the Fourth Amendment? Before we go on, I want to thank you for watching me here on YouTube. If you're new to the Lost Dash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lostdash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Lost Dash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Dash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Dash YouTube page. That's LAWSTACHE.
Today we're discussing a Supreme Court case, Kansas versus Glover, and it deals with reasonable suspicion and what is needed to pull over a vehicle. In April 2016, a deputy was on a routine patrol. He saw a 1995 Chevy 1500 pickup. He began to follow it. Now, this vehicle did not have any issues with it. It was in good mechanical order. But the officer simply ran the license plate through his system, and he figured out that this vehicle was registered to Mr. Glover, who had a revoked driver's license. Now, at this point, Mr. Glover, or whoever was the driver of the vehicle, was not committing any traffic violations. The officer, nevertheless, decided to pull over this vehicle without first trying to figure out whether the driver of the vehicle was in fact a registered owner of the vehicle, or if this car was being borrowed. So he pulls over this vehicle and finds out that it is in fact Mr. Glover who's driving the vehicle. He's charged with driving a vehicle as a habitual violator under this Kansas statute. But Mr. Glover argues that the officer never had reasonable suspicion to pull him over. Instead, the officer relied on impermissible hunch that the driver and the registered owner would be the same person. Now, I see a lot of confusion here on YouTube. Individuals discussing what is needed to pull over a vehicle. Some people say it's probable cause, some people say it's reasonable suspicion. So let's get rid of this confusion. The officers do not need to have probable cause to pull over a vehicle. They only need reasonable suspicion that a crime is being committed. And so let's discuss reasonable suspicion a little bit closer by looking at the case and defining it further. Under the Supreme Court's precedents, the Fourth Amendment permits an officer to initiate a brief investigative traffic stop when he has a particularized and objective basis for suspecting the particular person stopped of criminal activity. Although a mere hunch does not create reasonable suspicion, the level of suspicion the standard requires is considerably less than of proof of wrongdoing by preponderance of the evidence, and obviously less than is necessary for probable cause. Because it is less demanding standard, reasonable suspicion can be established with information that is different in quantity or content than that required to establish probable cause. The standard depends on the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. Courts cannot reasonably demand scientific certainty where none exists. Rather, they must permit officers to make common sense judgments and inferences about human behavior. Before initiating the stop, the officer knew three things. First, he knew the type of vehicle that was being driven. Then, based on the license plate, he knew who the registered owner of the vehicle was. And finally, number three, he knew that the owner of the vehicle had a revoked driver's license. Those are the three things that the officer knew before pulling over the vehicle. Now, all of us know that it is common for the registered owners to be the primary drivers of their vehicles. But not always. Sometimes people borrow somebody else's vehicle. But the court says reasonable suspicion can be less than 51% certainty, because being reasonable is not being perfect. Studies show that individuals with revoked driver's licenses often continue to drive their vehicles. So common sense says that the officer, just like any other individual with common sense, can believe that the registered owner of the vehicle would be the driver. So at the end of the day, the court says this is reasonable suspicion. Officers who run license plates and figure out that the individual behind the car could potentially be the owner of the vehicle and has a revoked driver's license. Well, in that situation, the officer can initiate a brief stop. But the court says this is case specific. Of course, other factors could come into play. For example, if this officer pulled closer to the vehicle and based on the information, he would know that Mr. Glover was in his 60s. But after looking into the vehicle, he saw a driver significantly younger. Well, that would diminish reasonable suspicion. So additional facts can raise reasonable suspicion or diminish reasonable suspicion. But as a base level, again, Kansas versus Glover is a Supreme Court case that says that officers who run the check on the vehicle and see that the registered owner of the vehicle has a revoked driver's license, well, they can pull that vehicle over, regardless of who the driver actually is. So why is this case important? Well, if you have a revoked driver's license, of course now you know that you can be pulled over and you cannot claim your Fourth Amendment rights. But be careful if you're an individual borrowing somebody else's vehicle. Because if the registered owner of that vehicle has a revoked driver's license, you, the borrower, can also be pulled over. And later, you cannot claim your Fourth Amendment rights. If you enjoyed this video, if you learned something today, give it a thumbs up. If you're new to the Lost Dash channel, please subscribe. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lostdash.com and check out some of the merch. Thanks for watching.